Good morning. This is Rick Marr, and thank you for joining us this morning. This morning, we're going to take a journey which mirrors the roller coaster we've been on these past few months. And like any roller coaster ride, it will come to an end. And if we hold steady now, we're talking about days till full opening and weeks instead of months and potentially years. So over the next 25 minutes of this presentation, and then with the question and answer session at the end, we're going to share with you how our clients are ending their roller coaster ride and returning to work with good, sound policies and procedures, and deciphering an increasingly and rapidly changing legal environment that leaves a lot of people with questions. And so we have a great panelist who I'll introduce in a moment to help us answer those questions. So there will be a lot of information this morning. So we are recording this session. You may return to it or share it with a colleague at a later date. The recording will be posted later today on our website, which is TURNINGPOINT.HCM/webinars. So you see that, TURNINGPOINTHCM.com, and then /webinars. And as I mentioned, we will have a Q&A session at the end of the presentation. So please use the chat function or the Q&A function on your screen, and we will address all of those questions at the end with our panelist and our partner on this journey, Doug Rowe. Doug Rowe is a partner in the labor and employment group at the law firm Certilman Balin. He has a broad range of expertise, which includes claims alleging discrimination based upon race, sex, religion, national origin, age, and disability, as well as wage and hour issues, labor arbitrations, and defense of employment-related claims under federal and state statutes. He is frequently quoted in the media about the Me Too movement and legislation affecting employers and employees. So Doug Rowe, we're going to introduce in a few moments, but I wanted to give you a little bit of his background. And so away we go. So here we are, the host and the panelist. And you can see Doug Rowe's contact information there and his firm's website. So what just happened? Really, and where have we been? Many of us feel like we have whiplash. We went from hearing something in the news in December and January that was going on in China to watching people sing in unity from balconies in Italy in the month of February to a total shutdown of the United States economy in March, right? The national emergency was declared by President Trump on March 13th, 2020. I mean, doesn't that seem like a million years ago? We're several months removed from that declaration, and look how our lives, our businesses, and our expectations for the future have changed. So dealing with this shutdown, on March 27th, Governor Cuomo announced the shutdown of New York State. Many other governors quickly followed. What we were worried about at that point back in March, there was a huge concern around telecommuting and policies and procedures and what's going to happen. And the questions that business owners were asking themselves was, could we do it? How do we do it? And all the technical questions that went along with that. We at Turning Point Human Capital Management even did some seminars on this topic back on March 19th and 23rd. And additionally, I was interviewed in Newsday on that very topic. So for business owners, one of the most interesting topics that I would argue that was talked about in the business world from March 27th on, there were only two questions that business owners wanted to know the answer to. And after they figured out if they were essential or not, the questions were, can I get a PPP loan or payroll protection loan, or the economic injury disaster loan? The SBA became all of our best friends, right? And we spent days and hours and what seemed like years thinking about these things. Now, what we're thinking about as we start to return to work. There's several fears. So the first fear is a fear of another shutdown versus the fear of not opening. And then, as Doug will address, the fear of what are the legal ramifications of, we've now all become the arbiters of what the return to work policy should look like. And Doug's going to address that for us. So we've been hearing from all of our leaders in all of their daily press conferences, the need to get back to work, the need to have testing, the need to detect hotspots, the need to and the ability to monitor our employees and give them a safe place to return to work, which I think creates so many questions. We need to assure our employees and our clients that our return to work policies are sound and abiding by what seems like the law, rule, or guidance of the day. So out of this, this whole thing came several terms and things that we never thought about in the past as being business owners. So, we never thought about asking our employees about their health, right? We were always told that was a no-no, right? So now we're almost thinking, who in the office has had the antibodies? Did I have the antibodies? Have I been exposed? Am I immune? Are my people immune? Are they exposed? And is there such thing as herd immunity? And all these sorts of things that were never thought about from a business leadership perspective, and more importantly, how do we deal with it from a legal and employment perspective? So for business owners, when there is uncertainty, there is fear. As I said, fear of another shutdown, counterbalanced by that fear of not getting their businesses back to work. And now that businesses are starting to reopen and that time is upon us, the crippling panic business owners are sensing when they're thinking about the HR and the legal component of the reopening, and what do they need to do to protect their businesses and their employees and make sure that they're not running afoul of these various laws. And in addition to those things, these past few months, although in the big scheme of things, it's only been a few months, but think about these few months. Budgets have been blown, and this affects so many things. Think about the revenue targets that are going to be missed this quarter, this year, and maybe even next year. All the momentum that a business had has been stopped. So, how do we restart the machine and not make further mistakes? To take this a step further, think about the assumptions you made when creating your budgets. You use those assumptions to set a course. How much material you need, how many employees, how many sales, and on and on and on. And all those things are missed, and they create other issues. And if you add in this potential legal component, could be devastating. So now think about your assumptions going forward. Are the old assumptions in your business still valid? What are the new assumptions going to be? And how are you going to measure? This is a big unknown and a tremendous fear. And this new fear that's kind of now on the horizon is, if I bring my people back to work and I have my head down, am I going to run afoul of new potential guidance and legal and employment issues? So think about your products and services. Many companies are questioning whether all of their products and services are still needed. In some cases, yes, and in other instances, no. Some business leaders are looking at new services that they could be offering. These are dramatic shifts that are happening in our businesses. And the backdrop is the unknown of where we will be if another shutdown happens, or if my workforce gets sick, or if I make a big mistake when I'm bringing everyone back and all of a sudden I have a legal matter on my hands or a government entity that I need to respond to. So for the employees, think about one of the biggest challenges has been is how quickly can I get my employees back? Who am I bringing back? And when can I get that process restarted? For many businesses, there have been furloughs, layoffs, and hours that have been reduced. this human component is going to be a big challenge. And that's why we have Doug Rowe on the line with us today. Think about, can you find all your employees? Or what if you cannot bring some of your key people back? Think about that HR stuff, recruiting, onboarding, retraining. These are big rocks that need to be moved. With that being said, what does your team look like when you come back? Do you need the same number of employees? How do you deal with kind of maybe downsizing and all those sorts of things? Does your business need new skill sets? What can the budget afford? All of these issues that the business owner has to deal with all happen in the dark without knowing about the laws, rules, and regulations and how they may have changed. So it's a big advantage for any business to have a great return to work policy and understand the things that they can and can't do as it relates to returning to work. So, even think about these things in your business, right? So, social distancing, is it possible in my office space? What if some employees don't want to do it? What if they feel uncomfortable? All of those things that we never thought about prior to March 13th are now human issues and part of our daily lives going forward. It never fails. My phone always rings when I'm doing one of these webinars. Personal protective equipment, right? So do people feel comfortable? How much will it cost? What if someone doesn't want to wear it? How do we deal with it? All that sort of stuff. So, from a dealing with employees and policies and procedures, these things are adding complexity to our business. In many of our businesses, we're doing testing, we're doing monitoring, right? So what happens if an employee says that they don't feel good that day? They have symptoms. These are things, how are we dealing with this? And how are we making sure we're not running afoul of any new laws, guidance, rules, regulations, those sorts of things? So with that, I'd like to turn this over to Doug Rowe. As I do that, I want you to see his bio there, so you can refresh yourself with it. Doug, are you there with us?
I am here, yes.
Great. Well, Doug, thanks for being with us today. I am going to turn it over to you, and you take it from here, and you let me know if you need anything.
Sure. So thank you, Rick. Thank you for the kind words. I thought it was interesting, Rick, your use of the word whiplash. I have a simpler word. It's really pivoting. We in the HR/employment law world are now faced with new laws which were not on the books several months ago, and the old laws which are being applied to a new set of facts that we've never seen in the history of the world. So, the legal lay of the land, I guess we could start with the emergency legislation that came out recently, the FFCRA, which was the Families First Coronavirus Response Act, contained essentially two acts. One was the Emergency Family Medical Leave Expansion Act, and the other was the Emergency Paid Sick Leave Act. Generally speaking, the EFMLEA expands the Family and Medical Leave Act. It applies to employees with less than 500 employees, and it provides paid leave, not unpaid leave, but paid leave for employees who need to take a leave for child care issues, where, for example, the employee's child's school is closed. These acts seem pretty straightforward, but applying them to real life situations takes some thinking and takes some compliance concerns. So I'll give you an example. At the outset of the pandemic, we were consulted, with virtually every one of our employer clients about layoffs and furloughs. And now that we're in the mode of looking at returning to work, employees who were furloughed are on unemployment insurance. Now the question is an employer required to comply with the FFCRA by offering the employees the FMLA leave of absence where they're on unemployment insurance? And the answer is, and this is an important nuance, the answer is yes, that even if an employee is on unemployment, they are entitled to receive the reinstatement offer. And this is important because, you know, if an employee stays on unemployment and was not given the notice of rights to take advantage of the FMLA leave, which again is paid leave, then the employee would have a claim under the FFCRA against the employer. It's important that when this reinstatement offer is made, that the employer document the offer, that the employer give notice of the rights to employees, and if the employee chooses to stay on unemployment and not avail him or herself of the FMLA leave of absence, that be documented as well in order to ensure compliance and avoid the claims. Aside from this emergency legislation, there are also state laws. The New York State has enacted the Emergency Paid Sick Leave Act, which entitles employees to a leave of absence, and that leave could be paid or unpaid depending on the size of the employer. It's important for any HR professionals in other states to be aware of the state laws as well as the recently enacted federal laws. By the way, when I talk about these issues and I talk about the compliance end of it, I think it's also important to realize that the lack of compliance is really going to turn into a list of post-pandemic employment claims for non-compliance. So the next issue we see, the next big issue we see is accommodation claims. Accommodation claims under the Americans with Disabilities Act or state laws, the Family and Medical Leave Act. You know, merely because a business is reopened, there's still going to be a psychological lag between an employee's expectation and the employee's willingness to return to work. So if an employee has a legitimate concern and a true disability and needs an accommodation for that, that's one thing. But, you know, we've been faced with situations where an employee may have generalized fears of returning to work, and that's not protected. And for that, employers won't have to provide an accommodation to employees. So that's something to be aware of. And again, it's important to document the discussions with employees. Speaking of which, if there's a request for an accommodation, it's important, it's crucial actually, it's an obligation under the federal and state laws that the employer engage in an interactive process with the employee. It's essentially having a conversation with the employee about the need for the accommodation, the length of the accommodation, whether the accommodation can enable the employee to provide the essential functions of the job, and other than that, you know, perhaps documenting the need for the accommodation as well. We're involved in a matter right now where an employee requested an accommodation to work from home because he had asthma and was concerned about his health and safety. My client accommodated that for quite some time, but now needs the employee back to the office. The employee is relying on a broad doctor's note that says that for now, he should continue to work from home. In the meantime, through the interactive process, the employee started speaking about not about his own health concerns, but rather about what the office is doing from a health and safety standpoint, what the governor's regulations, this is in New York State, what the governor's regulations are with respect to reopening of offices. And, while at one time we provided an accommodation for a disability, my client now is of the belief that there's really not a true accommodation that this employee needs. Rather, it's an accommodation that the employee wants because of generalized fears. So we're involved in that. As of now, we received a demand letter for a violation of the Americans with Disabilities Act, et cetera. And that looks like, from my perspective, that's going to be the first litigation arising out of this pandemic. One of the things that employers also need to be aware of is that with respect to the interactive process, it's important that the parties understand whether the employee can perform the essential functions of the job with the accommodation. And again, what we're gonna see a lot of is the accommodation request for working from home. The issue is, if the employee was able to work from home during the pandemic, why can't the employee continue to work from home? That's going to be an issue that I think every employer is going to have to contend with respect to the accommodation requests. Also, what we see is in the accommodation request world is that the use of PPEs. And if an employee refuses to wear a mask in the workplace, for example, and they do so based upon a disability or if they have a religious objection, those requests may have to be accommodated as well. It's just something to be aware of. Wage and hour issues. Traditionally, the wage and hour issues involving working from home, teleworking, involved tracking of time, overtime, and also, when I say tracking of time, and most states also require employers to provide meal periods to their employees. So when we talk about tracking of time, it's important for employers also to be aware that there's a compliance issue with respect to meal periods, even though an employee is working from home. It's just something to be aware of. One of the big issues arising out of returning to work is, what is compensable time? And if employers start to do medical screening, is that compensable time? It depends on how long the medical screening takes. It may or may not be compensable. If an employee has to report to the office and then has to wait a half an hour for some medical screening, that could be compensable time. Again, that's an issue for employers to be aware of. Also, in the wage and hour issues, now that employees are returning to work, we're finding that duties are being reassigned, hours are being reduced, salaries are being reduced. So one of the issues we see arising out of the return to work is misclassification issues. Prior to the pandemic, if you had a supervisor who supervised at least 2 full-time employees and had a right to hire and fire, et cetera, and performed the duties of an executive, they were exempt, and they met the salary threshold, they were deemed exempt and they were not entitled to overtime. Now let's assume you take back that same supervisor and all of a sudden he's only supervising 1 employee instead of 2, that his hours are reduced, his pay is reduced to a point below the salary threshold. all of a sudden you're going to have an issue where that exempt employee is now non-exempt based upon a revision of duties and reassignment of duties and reduction of pay. So again, that's an important issue for employers to be aware of. Also, with respect to the return to work, when you're dealing with reducing an employee's pay, some states like New York require employees to receive a wage notice where their salary or pay have been reduced. So again, that's a compliance issue, and that's important to be aware of as well. Those are the issues we see on the horizon with respect to wage and hour. Discrimination. We expect also to see a rise in discrimination cases. Now, let's go back to the traditional reduction in force scenario where an employee has to ensure that their reduction in force does not have a disparate impact on a particular class of people. So the same analysis that's involved in the layoffs should be made now in the return to work. So if an employer has laid off most of its staff and now is going to be bringing back half the staff, how are they selecting that half? And does it have a disparate impact on employees because of age? So when you, at the recall portion of returning to work, the employer should do an analysis as to whether it has a disparate impact on a particular class of people. There shouldn't be assumptions by employers about a particular class of people. There's a vulnerable population. Employers may assume that employees may be more vulnerable to coronavirus based on age or disability or pregnancy. That's if they make assumptions based upon that in recalling employees, they're exposing themselves to discrimination claims. I can tell you that, interestingly enough, that just yesterday, the EEOC issued new guidance, essentially saying that merely because somebody is over 65 years old and may be at an increased risk for health issues, that's not a basis for not recalling that employee. That's not a basis for treating that employee differently. The EEOC dealt with that in the same manner with respect to pregnant employees. One of the other issues that the EEOC raised in their new guidance yesterday is that employers should be aware of expanding their harassment policies to teleworking. We always think about, anti-harassment policies in the workplace, but now if employees are working from home, their home is now deemed to be the workplace, and the harassment laws will apply to that. So again, employers should ensure that they distribute their policies, and that it should be revised to include, emails between employees who may be working from home, text messages, etc. The EEOC also mentioned national origin discrimination. Don't assume that, merely because somebody is of a particular national origin that they should be treated differently. They specifically mentioned Chinese and Asians. And they also specifically said, and this is interesting, we've had this issue before, that employers don't have to provide an accommodation to an employee if an employee wants to stay home because they're concerned about exposing a family member to COVID-19. So again, this is the EEOC guidance that just came out yesterday. I'll mention a couple of other things on the legal lay of the land. Just to be aware of, just generally, there are WARN Act notices that may or may not have to be used in layoffs. There's a federal WARN Act, there are state WARN Acts. Just make sure that employers have to be concerned about that. We have a client in the city. in New York City that laid off employees, gave a Warnack notice. They recalled all the employees because they needed them back on the payroll because they received a large PPP loan and they needed to pay them, so they recalled them. Then after they satisfied the PPP loan, they actually laid them off again. So one of the issues was whether they had to give another Warnack notice. That was an issue we had to contend with. Also, with respect to that example, when the pandemic first hit, employers were not necessarily required to give Warnack notice because there's an exception to the WARN Act, which is the unforeseeable business circumstances exception. But now if employees are recalled and we get a second wave of the coronavirus, let's say in September, that scenario may not necessarily fall within the unforeseeable business circumstances because at this point, a second wave of the coronavirus may not necessarily be unforeseeable. Again, it's just something to be aware of. I'll just touch upon health and safety related tort claims. If an employee claims that they contracted coronavirus in the workplace, that's typically covered by workers' comp. And there's also a causation issue, which is how does an employee necessarily prove that they contracted coronavirus in the workplace? That's an issue, but it's still an issue that has to be contended with. It's an issue that really falls within the workers' comp insurance that an employer has and or their general liability insurance. And it's very important for employers to make sure that they have their workers' comp in place, that they're paying for their workers' comp insurance, and they're paying for their general liability insurance. We're also going to see agency investigations. It's very easy for an employer who's concerned about the workplace to contact the CDC or OSHA and just say generally that the employer is not complying with the safety and health requirements. There's an interesting issue. There's a new cause of action that exists. So there have been a few cases recently filed against Amazon and McDonald's, and the claim is that there is a lack of sufficient safety protocols in the workplace, which created a public nuisance. So this is an expansive theory in tort law, and what the claim essentially is that the employer unreasonably interfered with the employees and the public's safety and health by not sufficiently complying with the safety and health protocols. What could the damages be for that claim? It could be compensatory damages. It could be punitive damages. It could be anything any employee or patron wants to try to prove. And needless to say, these claims are class actions, and this is the first of its kind with respect to this type of claim, and it's working its way through the courts. It's just something else to be aware of. With a couple of other issues with respect to working from home, employers should be aware that they should take care of the IT end of their business and ensure that their trade secrets aren't being compromised through employees working from home. It's harder to control, obviously, when an employee is working from home on their own computer. It's something to be aware of. And needless to say, also the use of personal emails and Zoom when you have an employee working from home also has the possibility of exposing the employee to some claims. We also expect to see a rise of whistleblower claims. Also, with respect to the employee benefits side, we expect to see a rise in those claims as well. I've touched upon liability. I just want to mention also with respect to with respect to reopening the office, we're obviously dealing with a unique time in our history, and we're focusing on the safety and health issues. But now there also has to be, from an HR standpoint, a focus on diversity and inclusion. And I think it's more important than ever. I don't think anybody would argue this point, that diversity training is necessary. We read the news every day. We see what's going on. It's important for employers to be aware that they need to pay attention to their culture. They need to improve their culture. They need to accommodate requests, reasonable requests. In this time, employers may get requests from employees to attend protests. They should consider that as an accommodation as well. They should promote that employees should be able to speak up in the workplace. There should be an inclusive environment. Employers should be aware that employees have different perspectives on different views on different issues, and the employers should be trained. Supervisors should be trained sufficiently to be aware of these issues.
Doug, this is
yes.
Rick, and just from a time perspective, and we have some questions, so I want to make sure we get to them.
Sure.
Now, but just to kind of build on what you just said about diversity training. So, as you know, we do a lot of training. We trained over 8,000 people last year on sexual harassment and diversity training. So clearly, if anyone needs some conversation or guidance around that, we'd love to be a resource. So, with this said, we have a couple of questions that I'd like to share with you. And this one comes from a New Jersey client, a New Jersey business. And it says, in response to the questions, have you had any COVID-19 symptoms in the last 14 days? And the employee responds, yes, right? So I think this is doing with screening when people are getting ready to walk in. What does the employer do? And let's just say the employee says they exhibit symptoms in the workplace, such as complaining about a headache, or coworkers frequently coughing or sneezing. How should the employer respond in these scenarios as the symptoms listed by the CDC: fever, chills, cough, shortness of breath, right? So, I think here's the question. I think most of us have experienced one or more of these kinds of symptoms in the past couple of weeks. Are we to send an employee home for 2 weeks for fatigue or headache? Where does the employer draw the line? Obviously, these symptoms can be caused by many other non-COVID reasons, but unless the employee is working for a medical practice, do employers really have to, do they have the expertise to make the call on this? So it's a pretty big question.
Yeah, so obviously this is a new world. The symptoms that you're referring to, that the CDC lists as symptoms for COVID-19, are essentially the same symptoms that somebody with allergies could have. And I understand the issue, but in this time, in this new world, I think employers are well advised to err on the side of caution. Needless to say, they want to reduce the spread of the virus. In that case, the recommendation and sort of best practices, and this is basically all you can do, is talk to the employee in private. Ask what's going on. See if you can get some if the employee says, I have bad allergies, insist on some verification or perhaps testing. It's okay for an employer to say to the employee, go home for the day. The CDC actually says that that's the right message to the employee and the staff. If an employer hears an employee coughing, again, it's okay to send the employee home. And with respect to this, though, it's also advisable for the employer to be cautious, but not to discriminate. So, again, getting back to the point about the new EEOC guidance, if you have a 65-year-old employee that's coughing and a 45-year-old employee that's coughing, it's actually discrimination to send home the 65-year-old employee merely because that person is coughing. So it's just something to be aware of. But again, you know, the best advice is really to err on the side of caution. You may make a mistake. You may be sending the employee home unnecessarily. You may be requiring that employee to use a PTO day for that reason. The issue may come up, but this is the best advice we can give under those circumstances.
Great. And we have two more questions right now. So this question, for the paid leave entitlements under the FFCRA pertaining to childcare, when they say the paid portion is 66 2/3, is that determined based on the employee's overall gross rate of pay?
Yes.
Okay. Perfect.
Yes.
Excellent. And then we have one more question. We have an employee who's going out on emergency FMLA beginning on Monday, 6/15, to care for her child due to daycare closures. We're going to hire a temporary employee to take her place while she is out. We anticipate she'll be out the entire 12 weeks. If the daycare facilities open up and we call her back to work and she refuses, can we permanently replace her with that temporary worker? So would she be basically refusing to return to work?
Yes, that's the way I see it. Again, the act entitles the employee to this leave because they're unable to work because of a need to care for the child due to the daycare being closed. But if it opens, then you know the law does not apply. It's well advised. The employer is well advised to, you know, document the efforts and make a record of what happened and offer reinstatement. But yes, in that scenario, that employee can be replaced.
Okay, great. Thank you, Doug. So I want to thank everyone for joining. We're about up on it. Time's 9:45. So I want to thank 10:45. I want to thank everyone for joining. I especially would like to thank Doug Rowe for sharing his expertise with us. Certainly, this is a fluid time, and having a great resource like Doug Rowe on board is a wise strategy for any business leader, HR professional, etc. So if you'd like to chat with us or chat with Doug Rowe, please, you can look him up on Certilman Balin's website, where you can contact us or contact me, and I will make sure that you are connected with Doug Rowe. And Doug, again, thank you very much. I'm glad everyone's getting back to work. Hope everyone stays safe and have a great Friday. Thank you, everybody.